Thank you, Judge.
5,000 cash or surety.
And Your Honor, just so I'm clear, that's on the PHC docket for April 6th.
Welcome inside a busy Kansas courtroom where multiple cases move quickly through the docket. Drug charges, continuances, and potential plea deals are already on the table. Attorneys scramble to review evidence while the judge keeps everything moving. Watch closely, because one of these cases will end with a major plea deal today. Subscribe now.
Prosecutor here, there we go.
I'm here, Your Honor.
All right, great. This is the preliminary hearing control docket today. We have quite a few cases. Mr. De Hoya, your client is whom?
Judge, I've got two. I've got Mr. Orsit, who appears to be here by Zoom, and then Mr. Ziner is one I'm adopting from Richard, and I have he appears to be here by Zoom as well.
Okay. I'm not sure who's in custody and who's not. Is your client with you?
No, Judge, both my clients appear by Zoom.
All right. Don't see him. If you can get your client on, have him. There we go, sir. Thank you.
You're welcome, Your Honor.
We're going to go on the record in state of Kansas. Mr. Orset, I cannot pronounce your first name. Would you pronounce that for me, please?
Yes, it's Sangputan.
Thank you. The state appears by Mr. Sweeney. And Mr. De Hoya's appears as counsel. This is a fairly significant level 2 drug charge. We've had one previous setting where it was reset to today. So I'm looking for an announcement on this case, please.
So, Judge, I just got off the phone with Mr. Sweeney before coming on today, and we're going to want to review a couple things together, and I need to talk to Mr. Orset about the same. I'm asking for another continuance before the prelim gets resolved. I'm anticipating there's some likelihood we might waive it, but I do want to talk to my client a little bit more about the same before we go there.
Okay. Mr. Sweeney, do you have your KBI?
Your Honor, I don't think we do have the KBI. At least I'm not seeing it in the file, so not as of yet. But I do believe. Let me confirm this. I think there was a true narc that was done, and as the court's aware, we've been using that in place of. Well,
Right. I just am kind of trying to justify another continuance, and if we, if he waived today and we set it for jury, it would be an unknown as to whether or not you'd have a report in time for trial.
yeah,
So I'm going to go ahead and continue it then, and hopefully you'll get that report before too long.
yes, Your Honor.
Would you prefer the April 6th or the May 4th date, counsel?
Just a second, Judge. I think April 6th is. I have a conflict on April 6th. You said that was May 4th?
Yes, so we'll continue this to May 4th at 2:30, which is a Monday, by Zoom again. All evidentiary hearings are in person. All scheduling hearings are by Zoom. So this will be by Zoom, and you can make an announcement to me at that time.
Thank you, Judge.
Okay, if there's nothing further today, we are adjourned.
All right, thank you, Your Honor.
Thank you.
And I see Mr. Ziner here by Zoom as well.
Okay. All right, we're going to go on the record in state of Kansas versus Lamont William Ziner, 2025 CR 544. The state appears by and through Mr. Sweeney. Mr. Ziner is appearing by Zoom and with his attorney, Mr. DeHoyas. This is a continuation from 2-9 on a low-level drug charge, a level 5. Announcement to the court.
So Judge, just got off the phone again with Mr. Sweeney on this one as well. We have one thing we want to check on insofar as whether or not the defendant qualifies for certain opportunities, and if so, then we'll probably get this one resolved pretty quickly. So I'm again asking for another 30 days. That being said, Judge, this is just a simple possession, so it's not necessary to have the drug labs, but I think Mr. Sweeney knows what I'm getting at by asking for the continuance.
Any objection by the state?
None, Your Honor. Thank you.
All right, I'm gonna reset that one for 5/4 of 26 as well. Do you have anything further, Mr. DeHoyas?
No, Your Honor.
All right, then we are adjourned. Thank you.
Thank you, Judge.
Stay in contact with your attorney.
I sure will. Thank you.
All right, thank you.
Bye.
What other private counsel do we have here?
Looks like we have quite a few of these too.
I think I'm ready to go on 2 cases, Judge.
Okay. Which ones?
First one is going to be State of Kansas versus Christian Roy. And she's in my lobby if I can go grab her, Judge.
Okay, sounds good.
Thank you. Ready to proceed, Your Honor.
All right, we're gonna go on the record in State of Kansas versus Kristen Renee Roy. Butler County District Court Case Number 2025 CR 486. The state appears by and through Mr. Sweeney. Ms. Roy is present, appearing by Zoom with her attorney in his office, Mr. Jeffrey. And trying to figure this out here because these are misdemeanors.
I believe there was an amended complaint, Your Honor, that upgraded it to a felony.
Okay, I see that second amended to an ag assault. All right, do you want me to schedule a preliminary hearing for your client today, counsel?
Yes, Judge. I mean, we'll be waiving prelim. I don't believe that we'll be contesting this case. We should be able to come to a resolution. I spoke with Amber earlier this afternoon. I believe that a possible resolution is imminent in this case, Judge. We just want to. There's just a couple more things that we want to get taken care of before we present a plea offer to the court.
Okay. Do you think that you could possibly do that by April the 10th?
Oh, absolutely, Judge.
Okay, so I'm going to show a voluntary waiver of prelim. Does your client need a formal reading?
No, Your Honor.
All right, then I'm going to show a waiver of formal reading, a not guilty plea. I'm going to set this for a pre-trial conference at 9 a.m. on Friday the 10th. That would be in person unless you make a special request by motion. And just for the record, Ms. Norris can't try anything the week of the 13th, which we start juries on Tuesday, the 14th, or I do. So this will just be a pretrial, and in the event that you cannot resolve the case and you want a jury trial date, I will give it to you then.
Thank you, Judge. And I'm sorry, you said 4:10 at what time?
9 a.m.
9 a.m. Thank you, Judge.
Okay, thank you. We are adjourned. Do you have any other clients?
I do, Judge. If I could just have a couple moments to speak with Ms. Roy, if you need to take
Sure.
up other cases on the docket.
Sure.
Thank you, Judge.
Who would like to go next?
I have a quick one, Your Honor.
Okay, who would that be?
Lean Gary.
At this point, the court turns to another preliminary hearing control. The defense requests more time to review discovery before deciding whether to fight the charges or move toward a plea. That decision is critical. Evidence review can completely change strategy. If you were the defendant, would you fight or negotiate?
All right, we are going to, this is the first preliminary hearing control for Mr. Gary. Is he in your office with you or appearing separately by Zoom?
Miss Gary, and she's appearing by Zoom.
Oh, I'm sorry.
That's okay.
There she is.
Yes, Your Honor, it's
All
me.
right, great. Thank you for appearing. The state appears by and through Mr. Sweeney. Ms. Gary's present, appearing by Zoom separately from her attorney. I can't see today. Ms. Witzel? Is it Witzel?
Yes, Your Honor.
All right, thanks.
I'm just requesting another prelim status date on this. We're still working through some of the discovery.
Okay, great. And do you want April date or a May date? I have April 6th at 2:30 or May 4th at 2:30.
Let's do May 4th.
All right. All right, it will be by Zoom just like this. Once your attorney's had a chance to get all of the discovery from the prosecutor, she can advise you as to the best way for you to proceed. Of course, ultimately the decision is yours, but she can make an announcement on your behalf at that time. We'll either schedule it for prelim, you'll enter a plea, or waive, and we'll schedule it for jury trial, okay?
Okay, yes, Your Honor.
I will continue on your bond with the same provisions. Is there anything further, counsel?
No, thank you, Your Honor.
All right, thank you. We are adjourned.
Thank you, Your Honor.
You are free to go. Thank you.
Thank you.
Okay. Who do we have at the jail?
Judge, I've got two that are at the jail that are both ready for announcement.
Okay, who is
One's
that?
one's for announcement, actually, one's for a misdemeanor plea, so.
Okay. Tell me who they are, please.
So Miss Martinez is present at the jail, and we're just gonna ask for another PHC setting on that and make a bond motion.
Okay,
And then Mr. Wilkins is also at the jail, and that's gonna be a misdemeanor plea.
all right, sounds good. Let's pull those two out. Mr. Jeffrey, who else did you have?
I had Christopher Arredondo, and he's also in my lobby if you want me to grab him real quick, Judge.
Okay, yeah, you can get started. I'm gonna take up Ms. Martinez case, and then I can do your case, and then I'll do the Wilkins case.
Perfect. Thank you, Judge.
Thank you. All right, we're gonna go on the record in state of Kansas versus Christine Mary Martinez. It is Butler County District Court case number 2025 CR 497. The state appears by and through Mr. Sweeney. Ms. Martinez is present in person. She is currently in custody. Mr. Favre, her court-appointed counsel, is appearing with her. Looks like there was a bond forfeiture bench warrant from a failure to appear. Bond was reset at 10,000 cash or surety. She is being held on that bond. This is a preliminary hearing control on a level 5 drug felony. Announcement to the court, Mr. Favre.
Judge, this is the first time that we've been here with Ms. Martinez where she's been here, and I've spoken to Mr. Sweeney about a possible resolution. We're going to ask for this to be set for another PHC docket so he can inquire of the officers involved.
All right, so did you say you can't do April 6th?
Oh, no, I'm good on
Okay.
April 6th.
All right, I got you confused. So let's reset this to April 6th at 2:30 by Zoom. All right, you wanted to bring up the issue of bond?
Yes, Judge. Ms. Martinez, as court noted, did fail to appear, was relatively quickly brought into custody. She's actually on probation already in another county. From what I understand, she's got some kind of a core drug treatment of some kind in Sedgwick County, it sounds like. So we're asking the court to consider lowering her bond a little bit. $10,000 is too much for her to make. And I know that she did fail to appear, but she's not likely to be a risk any longer. She's now reporting in Sedgwick. She also has been productive in the jail. She's working in the kitchen and has brought a letter to that effect that she's gotten those privileges. So we ask the court to consider lowering her to a lower cash or surety.
Good. Well, she's been in for over a month, so I'm hopeful that this has gotten her attention. I can reduce it to 5,000 cash or surety, which is double what it was, which is fairly standard. And that gives her a smaller bond, but still a bond. Okay,
Okay,
Thank you, Judge.
5,000 cash or surety.
And Your Honor, just so I'm clear, that's on the PHC docket for April 6th.
Yes. At
Okay.
2:30. So stay in contact with your attorney.
okay,
And I would suggest that you just come to the courthouse unless you're confident that you have the equipment to participate, because the next bond forfeiture bench warrant will probably be a no bond hold.
okay. Where is the court? Over here?
It's at 201 West Pine at the Judicial Center here in El Dorado.
With the address on.
You might drive by it on your way out of town if you make bond.
Okay. Thank you, Judge.
And what happens is, for these dockets that are by Zoom, the court security.
Now things get more serious. Christine Martinez is in custody after failing to appear in court earlier, and that always raises red flags for judges. Her attorney pushes for a bond reduction, pointing to treatment efforts and good behavior in jail. The judge agrees partially, cutting the bond, but still keeping pressure on.
Takes you in, sets you down, all the equipment's ready. They advise the judge that you're here. There's no chance of you getting a warrant inadvertently because of some hiccup with the internet or the Zoom program or something, or
Okay,
something of that nature. But make sure you stay in contact with Mr. Favre, okay?
okay, thank you.
All right, thank you. All right, we are adjourned on that case. We're going to take up
60.
where did that other case go?
No. How much is that? Do you know?
Not that one. Not that one.
500 if it's.
I'm sorry, Mr. Jeffrey, who is your next client?
It's Christopher Arredondo, Your Honor. I apologize. He's Matt Levitt from my office is the attorney of record. I'm filling in for today, Your Honor. I apologize.
Okay, that's great. We're gonna go on the record in state of Kansas versus Christopher Michael Arredondo, 2025 CR 535. The state appears by and through Mr. Sweeney. Mr. Arredondo is appearing by Zoom in his attorney's office. This is a preliminary hearing control on a Did this one get bounced up to a felony?
No, Your Honor, it's just out of order. Count 2 is a possession of an opiate. Obviously,
Okay.
Yeah, sorry about that.
Level 5 drug felonies, the only thing that looks like the marijuana, and the rest are misdemeanors. Announcement to the court.
Thank you, Your Honor. We'd ask for one more continuance for another prelim status. I believe that Mr. Sweeney and Mr. Levitt have had some extensive conversations about this case. I think that it will be for possible resolution as well. Mr. Levitt's got to discuss a couple of things with Mr. Arredondo about how they're going to proceed forward with the case, but I believe that there have been just some discussions between counsel at this time.
All right. If there's no objection by the state, then I'm going to continue this case to April the 6th at 2:30
That's fine by the
by
state.
Zoom.
Yes, Your Honor.
That works. That works for the defense, Judge.
All right. I'll continue your client on bond, and we will recess on this case, and you're free to go if that completes your client list.
That's all I got, Judge. Thank you.
All right. Thank you.
Appreciate it.
And so we're back to Wilkins, Marshall James Wilkins. We're going to go on the record in his case. We need Mr. Fabre popping back in. There we go. It is 25 CR 231. State by Mr. Sweeney, Mr. Wilkins in custody. Mr. Fabre appears with him. Mr. Fabre, I believe that you mentioned that this felony theft is going to be amended to a misdemeanor, maybe that would result in a plea today. Is that correct?
That's accurate, Judge. Mr. Wilkins is going to enter a plea to an amended count 1 of misdemeanor theft. The agreement is that there'll be a joint recommendation for 12 months underlying, 12 months probation, the full restitution in this matter, which is $3,788.13, and no contact with the alleged bank in question, which is Community National Bank in El Dorado.
Okay. Is he going to serve the sentence, or what other recommendations?
No, it's 12 months underlying, 12 months probation.
Mr. Sweeney, do you have that information? I don't know if that came from you or Ms. Norris.
It came from Miss Norris, but she did forward me the email with respect to the plea, and that does seem accurate. I guess I would ask Mr. Fabre, does that restitution figure have to be paid up front before the plea is to be entered into, or just that's agreed?
No, that's agreed restitution.
Okay.
Oh, sorry, I muted myself. He has to pay that over the course of probation.
Okay.
All right. Well,
yeah.
The court will approve the motion. Of course, it's within the prosecution's discretion and control to charge and modify charges. So, Mr. Wilkins, it looks like you're getting the benefit of a reduction to a misdemeanor, which usually has to be theft of property under 1,500. It's alleged that you deprived Bestmark Express Inc. of check 34030 in the amount of $3,788.13. So that is a felony amount, but if you enter a plea of guilty today, they're willing to amend it to a misdemeanor so that you're not subject to any potential prison time. Are you wanting to plead guilty to the misdemeanor theft?
Yes, ma'am.
All right. A misdemeanor theft carries a maximum of 1 year in the county jail and up to a $2,500 fine. There are no mandatory minimums. And like I said, that's really the distinction. Any violations, any sanctions would be in the county jail, and you're not going to be subject to serving your time at the Department of Corrections if you were convicted. All right. Do you have any questions about the maximum sentence, the fact that there's no mandatory minimum provisions?
No, ma'am.
You understand that you had a right to a trial by jury on this matter, whether it was a felony or a misdemeanor?
Yes.
All right. Let me explain to you some of the basic rights that are afforded to you if you wish to go to trial. And if you waive your right to trial, what you're giving up. You have the right to the presumption of innocence. You have the right to expect the state to prove their case beyond a reasonable doubt. That burden never shifts to you. You have the right to representation of counsel if you cannot afford one. Of course, like you already have, one's appointed to you. That's your Sixth Amendment right. You also have a Sixth Amendment right to confrontation, which means the state has to produce their evidence in the courtroom with live witnesses, subject to cross-examination by your attorney. You have a Fifth Amendment right not to be compelled to testify, which also means that you don't have any obligation to do anything. You don't have to present any evidence. If you wish to call witnesses on your own behalf, you may, but you need not do anything. And the jury would be instructed not to consider the fact that you may have not produced evidence or testified as any indication or inference of guilt whatsoever. At the end of the day, their deliberations would have to result in a unanimous verdict. In other words, in order to return a guilty verdict, all 6 in a misdemeanor or 12 jurors for a felony have to agree on the same outcome, that the state met its burden and proved you guilty beyond a reasonable doubt. You then, once convicted, could appeal to the Court of Appeals in Topeka to have your trial transcript reviewed to ensure that everyone properly followed the law, that there was sufficient evidence to support the jury's verdict, and that most importantly, none of your constitutional rights were violated. Do you have any questions about those rights or how a trial works?
No, ma'am.
Do you wish to waive your right to trial at this time?
I do.
This is the turning point of the hearing. Before accepting any guilty plea, the judge carefully explains every constitutional right the defendant is giving up: jury trial, presumption of innocence, and the state's burden of proof. It may seem routine, but legally, this step protects the plea from future challenges.
All right. Last but not least, I need to make sure that you are of sound mind and good judgment, that you're not under the influence of anyone or anything, and that you're comprehending what's going on. How old are you?
45.
What is your highest level of education?
GD.
All right. Can you read and write at least a 10th grade or high school level?
I can.
All right. So if you were provided documents or given instructions, you could follow those?
Yes, ma'am.
All right. Do you have any diagnosed mental illness or traumatic brain injury that I should be aware of that might be affecting your judgment today?
No, ma'am.
Are you taking any prescription medications?
Nope.
Are you under the influence of any illicit drugs or alcohol at this time?
Nope.
Is anyone threatening you that if you go to trial and you divulge certain information that they intend to harm you or your family or someone or something you care about?
Nope.
Is anyone trying to promise you an exchange for your waiver of trial, goods or services or something of that nature to induce your plea?
No.
Is any third party benefiting from this plea agreement that I may not be aware of? As the prosecution made promises to a family member or offered other things outside of the courtroom that I'm not aware of today?
No, ma'am.
All right. Are you satisfied with the services of your attorney?
Yes, I am.
Have you had plenty of time to visit with him?
I have.
Do you need any additional time to ask him any questions before I ask you how you plead?
No, I've already talked to him beforehand.
All right. Very good. Mr. Favre, do you know of any reason why I should not accept his plea to the amended count 1 misdemeanor theft?
Do not, Judge.
All right. Sir, how do you plead?
I plead guilty.
All right. Tell me what happened that could constitute a theft of property on August the 29th, 2023 in Butler County, Kansas involving Bestmark Express Inc.
I had cashed a check that I knew wasn't legitimate.
Okay. So you took property of another without their permission or authority?
Yes, ma'am.
All right. I will find you guilty of theft. It's been designated as a prosecution as a misdemeanor by way of modification of the charge. I will find you guilty of a Class A misdemeanor. If you're ready to proceed to sentencing, I will do so, Mr. Favre.
Yes, Judge, we are.
All right. Recommendations from the state?
Your Honor, in keeping with the plea agreement and what I think is essentially been announced already, we're asking for 12 months in the Butler County Jail. We're asking that the defendant be placed on a 12-month court services probation. Part of that probation is not a fine, but we are requesting restitution in the amount of $3,788.13. And I think that would be payable towards Community National Bank for their reimbursement of the victim. And no contact as a condition of probation is being recommended with the victim, Best Express, or the bank, Community National Bank. All standard conditions above and beyond that. Court costs, supervision fees, would ask the court to take a look and order, if appropriate, attorneys and bids fees as well. I think that's about it, Your Honor. Thank you.
All right. You're not aware of any cases he might be on probation or parole for, anything that needs to be ran consecutive by law?
I know he has some criminal history, Your Honor, but I'm not. And then, given the fact this is a misdemeanor, I'm not aware
Okay.
of that.
All right, very good. Mr. Favre?
Judge, Mr. Sweeney accurately recites the agreed upon disposition. I would just inform the court in relation to attorney's fees that they are $1,100 in this matter. We're asking the court to consider waiving all or a portion of those. Mr. Wilkins is currently in the jail, has been in the jail for almost 2 months. He is currently going to be going to a halfway house upon his release here. And so he's not employed. He's going to have to look for work. And he has a significant amount of restitution to focus on as well. So we'd ask the court to consider waiving his attorney's fees in this matter.
All right, Mr. Wilkins, anything that you'd like to say before I impose your sentence?
No, I think you guys have touched on everything.
All right. For the crime of theft, I'm imposing a sentence, the maximum sentence of 12 months in the county jail. I will place you on a reporting probation with court services for 12 months and give you jail credit for whatever days you should receive that should be noted in the journal entry of conviction. I am assessing court costs. I'm going to order standard conditions of probation with court services. So as soon as you're released, you need to be showing up at their office or giving them a call to get an appointment. A part of your probation will be that you make regular payments. And that should be at least a minimum of $100 a month. So you need to get a job, and hopefully your halfway house will give you an opportunity to work without a lot of living costs so that you can make reparation or restitution the amount of $3,788.77 payable to Community National. I'll ask that you not patronize the following businesses: Bestmark Express Inc. and Community National Bank. There are other conditions of probation: no drugs, no alcohol, don't violate the law, report as directed. They will randomly UA you to make sure that you're not using illicit substances and that you're remaining drug and alcohol free. No bars, no taverns. And most importantly, don't violate the law. You have 14 days to appeal. This is as a misdemeanor, a conviction that you can expunge in 2 years, but you have to be successfully terminated from probation. Your case has to be paid off in its entirety, and you have to have not committed any new offenses whatsoever during that time period. Do you have any questions? No firearms as well.
No, ma'am.
All right. If there's nothing further, then we are adjourned on this case. Thank you.
Thank you.
Mr. Farley.
Oh, I
Thank you.
do need to order the bids fee, but I have to waive the attorney's fees because he's not presently employed and I cannot make the requisite findings. So I think that's it. Thank you.
Thank you.
Thank you.
Probation.
Thank you, Your Honor.
And just like that, the final case concludes with a guilty plea to misdemeanor theft. The defendant avoids felony exposure, but must serve probation and repay over $3,000 in restitution. A reminder that even reduced charges carry consequences. Like, comment, and subscribe for more real courtroom breakdowns and cases.